in Virginia, number one, possession is a legal concept, okay? It requires control and it requires knowledge. So if you're walking around with a purse and someone slips something into your purse, you're not possessing it if you don't know about it, even though you physically are controlling it. The reverse is also true. If you know something is sitting across the room, but it's not yours, and you don't have the ability to claim it or take it, then you're not possessing it because you don't have control over it. The control doesn't always have to be physical, right? It can be what's called constructive. So you're driving in your car and something that belongs to you is next to you within grabbing distance, or it's locked in a place that only you can get into, like the glove box. That's possession. And so that concept applies to all sorts of things. One of those things is marijuana. A lot of people in Northern Virginia are in Northern Virginia because they've just come from somewhere else, like DC or West Virginia or Maryland, and they don't realize that Virginia still criminalizes marijuana. They don't criminalize the consumption of it, they criminalize the possession of it. There's a small difference there, but if you come from a place where you got it legally and now you're here, that's not going to necessarily save you. So there is no amount of marijuana that is a minimum threshold to get charged. You can literally be charged for the smallest crumbs or leftover substance of it. You can be charged with the liquid form of it. You can be charged for the burnt form, the unburnt form. You can also be charged with having what's called paraphernalia. It's basically drug tools, scales, razors, blunts, things of that nature, vape pens, vape cartridges. Those are less common, but still show up frequently. So with marijuana, the number one issue, of course, for them is they need to prove that it's marijuana, as opposed to something else that maybe looks like marijuana or smells like marijuana. And they will have to do at least a field test, if not send the substance in question to the state lab that will do a more comprehensive test to confirm that it's marijuana. So once that is determined, the next question is, were you possessing it? So they look at things, how was it packaged? Where was it? Did you make comments as if you knew about it? Was it, something that people around you could smell? Things like that. Sometimes there are other people around. Sometimes it's not your car. Sometimes it's in a place where other people have access to, and there's defenses about who was actually possessing it. Multiple people can possess the same thing. There is such a thing as joint possession. So then the question becomes, how much was it? The law will change sometimes what the charge itself is, depending on how much marijuana there was. What form is the marijuana in? Virginia actually charges felonies for THC oil these days. You could have the same amount of that in physical form and it would be a misdemeanor. And then towards the end of the case is, what's going to happen to you. Even though marijuana is illegal in Virginia, we still have a pretty lenient policy on it, at least as far as the first offense goes. It's not punishable like a normal Class 1 misdemeanor is. There's only a maximum of 30 days in jail. And if it's your first drug offense, you would be eligible for the statutory first offender program. The idea there is you, for 6 months, do some inconvenient things, basically be put on marijuana probation, and if you're successful at the end, the case will be dismissed. But that causes a whole nother series of issues about, whether that whole criminal event is expungible. If you get a marijuana conviction or you're placed on the first offender program, your license is typically suspended for 6 months. You're eligible for a restricted, but that's, still a big inconvenience for a lot of people. The first offender program itself is going to require some community service. It's going to require you to take sort of a substance abuse class. There's probably going to be a fee with that. like all forms of probation, you're going to be placed on what's called good behavior, which means you have to avoid getting new legal convictions within a certain period of time afterwards. Otherwise, they will just take you off probation and convict you. So the fines are not really a big issue in these cases, and jail time is usually not a big issue. It's more about, is this going to be the first case that makes you have a criminal record? Is it going to be something that people can still see going forward, even if it got dismissed? And is it going to affect your driving status or your driving abilities for a number of months into the future?